Oh, that's right. The lucky guy. Hello, everybody. It's the IMMPAct litigation team with you today. Absent our dear friend Jesse. Jesse is in Cooperstown, New York today, playing ball. It's a great place, Cooperstown. Have you been there, Aaron?
No, I haven't.
Greg, have you been there?
Just in the neighborhood. I haven't been.
Oh, man. Cooperstown is really a magical kind of place. Kind of the quintessential American town. You remember from the early part of the 19th and 20th century. It's kind of, that's how it is, right? It's kind of cool. I still have my baseball bat that I got there made up just for me, signed by me. It's pretty cool. Hey, so we wanted to talk first today because we've got news in so many cases going on. Let's start with the 601A litigation because it's really kind of the biggest one right here. And we have filed our response to the government motion to stay. So let's just set this up, Aaron, in a procedural posture. So we filed the complaint. Government files an expected motion to dismiss. We file a response to the motion. They file a reply. And then the next day, that judge reassigns the case to a different judge. Still don't know why. That judge then says, hey, I've got other cases. What do you all people think? Tell me what you think. And then it comes to light that one of the cases from a different court in the circuit, but a different state, they get a decision first. They filed after us, got a decision first. And it's a bad decision, which honestly, from the judge they got that from, I'm shocked. But who knows? Maybe it was crappily written. I don't know. I don't know what the deal was. They appealed to the Ninth Circuit. So the government finds out this other cases appeal to the Ninth Circuit, which controls our stuff. And they file a motion for stay. It says, Judge, this case is dispositive of our case, which is not, by the way. No. Dispositive means it controls us. So it doesn't control us. Plus, ours is fully briefed. It is routine that different district courts in the same circuit issue opinions on the same facts and law every day of the year. And sometimes they're inconsistent, sometimes they're not. So we filed, Aaron, our response yesterday. Now, Zach, I love that. Zach did the initial draft of this. It was fantastic initial draft. But I want to get your thoughts on the filing, what you thought about it, and where we'll go from here.
Yeah, I think first of all, the opposition that we just put in to the motion to stay, I think is very strong. So I'm very happy about it. And one of the things off the top of my head that really stands out to me about this kind of case is that a stay for while another case, a single case goes on appeal. So the other case is just one plaintiff. Okay, so while a single case is on appeal for this kind of case, doesn't make sense because the appeal could last up to, 1 or 2 years at the Ninth Circuit. And in that time, there's at least a decent chance, no matter how slow USCIS is, that they could decide the waiver because they haven't paused working on the waivers, at least in theory, on that case. And so then we could wait, a year and a half and then have the case mooted out and we're back to square one. So staying our case to wait for that case doesn't make sense for a lot of reasons, but that's one of the ones that stands out to me of just, what are we doing? So it doesn't make sense to me. And I think the response that we put together along with our colleagues at AIC, who did a great job on this, and at AILA, who did a great job on this, I think it's really strong. And I'm hopeful that the judge will see through this.
I do.
Greg, I know you read it, Greg. What's your take?
No, I thought that the response was great, and Zach did a great job, and also there was a really solid additional effort put in by Leslie Dillon at the.
Leslie is amazing. She's got 40 years of experience in this, just fantastic.
And it's kind of a reminder, with Kate Moy and with Jennifer Cogley and others, we have an expanded team for this case that's exceptional. And it's really, I think, made every pleading that's gone in on our part and every strategy response that we've done has really had a really great pool of people that have been contributing to that. So that's something that's a little different than in other cases as far as having some of these outside organizations helping us, but it's certainly, I think, been helpful here.
Greg, it's a lot like a baseball team that's making a run for the pennant right before the trade deadline. They're really good. And they trade to get some great players for that pennant run.
I have a different analogy, which is the Major League Soccer. They're playing the League Cup right now. And I didn't realize, because I'm sort of like new to Major League Soccer, Nashville just got a team recently. they have goalies that are specialists that only come in for the penalty kicks. And they have Nashville has a guy who won the game the other day versus Cincinnati because of and that's all he plays. He's not a regular goalie. He doesn't play during the game. He only comes in at the end during the penalty kick. So I feel like there's sort of like really super specialists on some of these issues. Leslie in particular, I think is really
fantastic. Fantastic. I'm excited to be litigating this. I think it's a great case.
I did want to give a data update.
Please, Greg.
So we don't have any new approvals since last week, but we're continuing to see this pattern of large numbers of case transfers being logged in. We've had 30 in the last week, all the June and July. So what we've started, they're definitely going chronologically in these transfers that are happening right now. And they've gone, over the last couple of weeks from the earliest cases that we had now to the cases that were filed in July 2020. We still don't know exactly what that means, but there's definitely, you can read what you want in terms of that happening. But that was just yesterday. There were 30 more case transfers.
And I wonder if we'll get any further insight into what these transfers are there's an engagement coming up, right, for Heart Service Center.
Yes, I have signed up for that. Got my invite. We'll find out what's going on. I was actually looking at the Heart PowerPoint, which was just released by USCIS from their April meeting, which doesn't mention 601As at all. Of course it doesn't, because they weren't going to do 601As, and we forced them to add 601As to the Heart Service Center. So, but what reminded me as I read that PowerPoint, though, is 388 employees to start with, all remote. So, this whole file transfer, it's getting scans, scanning the stuff in, sending one file somewhere, sending the scan somewhere else. But we'll get some good answers. And I think many of you that are our clients, you probably signed up as well, because it's public engagement. Anybody can listen into it. So I would suggest that if you're really interested in the details of how the sausage is made, this is a good thing to sign up for. But just understand, when they use the word public engagement, they're not inviting your engagement. They're asking you to listen to them talk for 30 minutes. Just to be clear.
I would also what's interesting is when you sort of see the log for each of these cases, that like a typical case will show 1, 2, 3, 4, 5 different transfers. So I'm looking at one that was a July 27th, 2020. It was initially received, and the fingerprinting came a couple of days later. The fingerprint fee being received, but they had a transfer on February 9th, 2023, February 10th, 2023. This is just what the log is showing. Case transferred to another office in May 2020, May 3rd, 2023, and then May 4th, 2023, I guess is sort of part two. One is transferred, one, I guess it's outbound and inbound, and then another transfer August 7th. So, I am presuming they're using case transfer to mean broader things than actually, that there's a physical movement of the case from one place to another. I think that might be the scanning is when it's scanned, it's considered transferred out and then transferred back in. It's hard to say, but that is something that on each of these cases, each one have had multiple transfers up till this point.
The other thing that I find interesting about this is somebody asked, why do they keep filing these motions? So a friend of ours, Matt Halpeck, is a kind of a FOIA guru. He loves FOIAing policy. And he FOIA'd and got in response a PowerPoint presentation to USCIS. It looks like managers and directors about how to deal with assistant U.S. attorneys in lawsuits. Did you guys see this?
No.
This is crazy. And basically they said, the U.S. attorney is going to want to settle the case right away. They're going to want to get it over right away. Don't let them. Slow it down. This is from the FOIA. So I would love to figure out a way to get these FOIA results into a filing in front of a judge. I think
the judge would be very unhappy about that. If the strategy is to clog up the courts.
Their strategy is to delay, and to their own lawyer. That's the thing. To their own lawyers, they're talking, not to us. So they're making their lawyers. And this actually jives with some private conversations I think we've all had. Yeah, I got to file a motion to dismiss, and we see it in our own practices. They used to never file these. Now they file them almost all. It's like it's reaction. It's built into what we do. So it's going to take longer to do stuff. But that's coming from their client. Congrats. Shout out to Matt.
I think their strategy is fairly obvious, which is they're trying to break us. If they fight back on enough of these cases, and it seems like it's going to be harder and harder for plaintiffs to get settlements and get these cases adjudicated in a timely manner, then they're going to get sued less. And it's actually the opposite, because they're spending so much of their resources on this litigation.
Because they do have to pay the Justice Department. I mean, there is a cost to USCIS to this.
Yeah.
Now, the other thing is really interesting. They do win occasionally on this crazy. They just won a case in the 11th Circuit where I am. It's a terrible circuit, by the way, out of which came Patel. Another case that basically said, when the government revokes something, there's no judicial review. None. Even if the underlying facts could be judicially reviewed because it's discretionary, no authority to review. That's insane. But that's probably going to go to SCOTUS as well, because now we have a circuit split. So the government's trying to use a law written in 96 to limit the ability to sue. That's why we have to pound them into the ground right now. I'm not hiding it in a FOIA. I'm saying it publicly. Ms. Chadu, Director, Madam, we're going to keep suing you because you're not talking to us. All right. You have any update on the 601 litigation, Aaron?
No update. We're seeing some. Let's see. We're seeing some. I think. I don't know, Greg, if you have any actual data on what we're seeing from plaintiffs.
No, the scraping that we have right now, and our friend Casper, who helps on this, is going to hopefully give us a tool for the actual cases. But we're looking at basically tools to show that they're adjudicating cases out of order. So we have a lot of data now showing, approximately the 14,000 or 13,000 cases that are pending in the 601s, and we're now able to sort of graphically see how they're adjudicating, and that they are indeed doing a lot of cases that are not in order. So we have the evidence now to show that.
I mean, beyond, procedurally where we are is there's a motion to dismiss that's been briefed. It's fully briefed. The court's had briefing since July 28th. The last government brief was July 28th. So they could set a hearing. They could decide the motion to dismiss. And, there's nothing. This isn't something that happens automatically, but anecdotally, I think all of us see a lot of times, if you survive the motion to dismiss, pressure ratchets up on the agency to, hey, why don't we just get rid of these cases? So I'm hoping we'll get a decision on the motion to dismiss sooner rather than later. But beyond that, we're just waiting.
And we are now assigned to the chief judge. Is that right, Aaron, in the district?
Yeah, that's the problem in these cases, is that they take a long time to get to the point of a decision on a motion to dismiss. There's a lot of steps along the way. So in a lot of our cases, we're just waiting to get to that point.
Yeah, it's not like the judge says denied. They have to write a written, detailed opinion about why they're denying it, and that just takes time.
Yeah.
So, but Aaron, you bring up a good point. If you survive a certain point in litigation, you get results. And that's exactly what happened in our EB-5 litigation. We're announcing today that we've settled this case. We'll be filing that later today. And the key in that case was that we survived a discovery request. The government argued you don't get discovery when you're fighting a delay case. And our suggestion was, yes, you do, because the reality is, how do we know why you're delaying a case? Are you really delaying a case? Are you singling people out? And so we didn't get all the discovery we wanted, because we wanted a lot. But we got a lot of good discovery. And what we got made it quite clear that we were right, that lots of cases were taken out of order, that things weren't right, that they weren't. In fact, it was so right that they announced the Monday after the Friday when they produced our discovery, they announced the policy change and how they're handling EB-5 cases. The only reason that happened is because of this case. And that's a good thing for everybody, because what they were doing before was, regardless of whether you had a current EB-5 current priority date, you were in line with China. They weren't doing your case.
You're also revealing something about about these cases, which is that the government wants to avoid discovery almost as much or even more than they actually want to avoid having to adjudicate these cases. So, when that's why the motion to dismiss, when you survive that, why all of a sudden your negotiating position changes so dramatically.
So we're very happy about that. Happy that'll be over probably today. I'm just waiting on the draft from the government, and we'll file that with the court. Court will almost assuredly sign it right away. My experience, unlike motions to dismiss, when you file a stipulated dismissal, like minutes later, the judge signs off on that thing. Pretty good. Unless you're Hunter Biden, and then you get questioned about what's going on here. Now, we got to talk the last thing. Other big news, Greg.
Mm-hmm.
So we, along with some great colleagues, have filed in Washington, D.C. a request for the government to cough up, I don't know, somewhere between $50 and $80 million, Greg? 80 million?
We won't know until we get discovery.
We don't know. The government will tell us how much money it is. There's a lot of people that they stole money from. They stole money from refugees. That's what they did.
Yeah.
So the government filed a motion to dismiss. Their answer was due yesterday. Government filed a motion to dismiss yesterday. We're very happy with the motion to dismiss in this case.
Well, they don't actually argue that they don't owe the money. That was sort of the most interesting thing to me about it.
There's nothing about it.
They sort of like basically they almost admit that they owe the money in terms of laying out the history on the case. And then their argument is, but you sued in the wrong court. You have to,
which we know we didn't. And why do we know we didn't file in the wrong court, Greg?
Because we're not seeking damages.
That, and the district court judge who wrote that decision last year is the judge assigned to our current case.
Right. So just so people understand sort of what I mean when I say we're not seeking damages, because I think sort of the layman's view of what damages are is like when you get money on there. It's not damages are a substitute to compensate when you have been harmed. So it's a way to come up with a dollar amount to compensate you for a loss that you suffered as a result. So it's sort of a substitute for the value of the harm that you've suffered. Restitution is when you actually are just having money returned to you that you have paid in, and the government in this case has wrongfully kept that money. So just returning money is not the payment of damages; it's restitution. It's a different remedy the court is providing, and that's really important in this case because the government is claiming that something called sovereign immunity, where you can't sue except in very limited circumstances for monetary damages from the government unless you follow a specific set of rules on there. That's and that's was interesting because they really kind of like glossed over that whole issue in their response and just basically said, you're seeking damages, you need to file in another court, and we probably owe the money, but you should sue us there.
Well, what's interesting is we filed initially in that other court. And because there was a certain procedural step that we didn't take beforehand, we had to dismiss that case. And it just made sense from a procedural point of view. And this other case that our judge had recently then decided that we should file in district court. And so we have, again, another great A team is joining us in that case. We're very grateful to them for doing this.
Do you remember we had this discussion about the fact that the government with the Ukrainians in the Shumalina case and now in this case they've been really, really careful in terms of criticizing or saying anything that these people don't actually deserve anything on there. In Shumalina, they didn't file anything. All they did was tell the judge, well, I mean, they filed things, but they kept telling the judge, we're in a settlement negotiation, judge. We're not disputing anything. They didn't want to go on the attack against Ukrainian refugees. And it's interesting that that's kind of continuing with this case, which is, again, they're not saying the plaintiffs don't deserve it. They're just saying they didn't follow the procedure and they need to follow this procedure, judge, even though if we actually did that, they still would probably come up with some reason why the procedure wasn't followed. But that I find that interesting with this, that they are still basically not willing to go on the attack against the plaintiffs.
There you go. So a great week. Let's answer some questions here. We've got Norma. Good to see you, Norma. Hayes, can you please clarify what August 11th will look like for 601A case? We get some decision on that day.
That's the noting date on the motion for stay. So the noting date just means that's when it's going to be ripe for decision. That's when briefing will be complete. The government will have to have given their reply brief to our response that we just submitted, and then the judge can make a decision. It does not mean that we will get a decision on that day. It could be that day. It could be next week. We don't know. It could be
3 months from now.
Yeah, we just don't know.
I don't think so, though. I mean, and you know, the thing is, the judge put the motion to dismiss. I mean, he put the motion for class cert to the side, but didn't do that to the motion to dismiss. Because if he denies the motion for stay, then he has to decide the motion to dismiss. Now, it makes sense for him to do the class cert first and then do the motion to dismiss, because then he can dismiss everybody. But if he's going to dismiss people, anyway, that's kind of how I'm looking at it. But nothing's going to happen on that day, is what I think. Genesis, good morning. If there's a hearing, okay. If there's a hearing, by the way, I think this judge allows for Zoom hearings, and you will be able to zoom in and listen to it. You won't be able to see it, but you'll be able to listen to it. So
no turn off comments.
Yeah, you can, and you will be able to comment or anything. That's good. Let's see. William wants a decision. Any updates on H-1B? Well, you know, I disclosed, you know, right before they announced the lottery, I told you they were going to do a lottery because I did the FOIA. Where did Aaron go?
He'll be back.
So I got the FOIA the day before they announced the new FOIA. Not that those are connected, but it was quite obvious from the FOIA results that they're getting about a 42% file rate.
Low.
So they've notified 180,000 people to get to 85. And I think there's going to be a third lottery, Greg. I do.
Yeah, they're in uncharted water right now with a lot of people, I think, nervous about filing in the first place. There's not a lot of clarity as far as how many real jobs are actually out there, and how many people are being selected by, you know, basically what's been going on is there's sort of been a collaboration amongst employers, agents, and these people that have been filing multiple applications to try and up their odds. But I think a lot of people that depends on a lot of people sticking with the conspiracy, essentially. And I think that we're starting to see that a lot of people are dropping out. So if they get selected, if the employer gets selected, they're not willing to apply, or maybe some people have already been selected and they're applying. They don't need to apply again. But it seems like sort of a normal calculations that they're using to determine they you know, in a normal year, they will select over the amount of actual visas under the assumption that a certain number are going to be denied and a certain number of people are not going to apply. And all those assumptions that they've used in past years don't really apply right now. So they don't know at the agency. They just kind of picked a number and they're going to look and see. And I guess, Chuck, what's the so it seems like their pattern is usually about 30 days after the deadline for filing.
Yeah, I mean that is the exact date last year, 2 years ago, when they denounced the lottery after we sued them.
What is that date? So that's the date probably for the third lottery if it happens. What date is that?
It would probably be let's see, it'll be in late October.
Okay.
August. It might even be November. I think it's November.
So your question on reform, there is a regulation that is floating around that nobody seems to know. They have seen the text of what that regulation is. It was sent months ago to Office of Management and Budget, which has to give their clearance. But I haven't heard of a drop date for that as far as when that's
nothing at all.
CIS. And my guess is that they are probably revisiting that regulation in trying to update it to deal more. I have a feeling that regulation didn't deal with most of
No, because it was sent up before this year's monstrosity, which, by the way, you and I predicted live on the air that was this exact thing was going to happen.
Yeah.
Now, I think next year
you said 1 million, so you were a little.
I didn't say a million. It was on 800,000 basically. I mean, hey,
close, but even that was eye popping when people.
Yeah,
saw
it was a shocking number. You know, in the FOIA, what was really interesting was they went from last year they had about 130,000 duplicates. This year they had 400,000 duplicates.
Yeah,
it's like, come on, this is a problem now. But it's all about the money, Greg. 3 years ago, they made $3 million. Last year they made $5 million. This year they made $8 million.
But next year, how much are they planning on charging for this?
$255. That's not going to deter. $10, $255. Why would that deter anybody?
Right. They're going to say, Judge, how are we going to clear the backlogs and all these other categories they're suing us on if we can't screw over this other?
Anyway, so there you go. Now, will Congress change the law? No, Congress isn't going to do anything. There's a lot of great bills pending in Congress. None of them are going to pass. Greg, agree or disagree?
There are a couple of bipartisan ones that might have a shot. Doctors and a couple others.
Well, what they're really making sure there's a cadre of anti-immigration dudes that are making sure none of this gets attached to the NDAA, the National Defense Authorization Act, which is where we've gotten a lot of great legislation in the past, including 245I back in the day. But they're
what was the EB5 bill last year attached to? It was it wasn't on its own. It went through.
No, I don't remember, but that was a kind of a natural kind of that had to happen because the program was ending. People screaming bloody murder about not investing in America during an upcoming recession. It just made no economic sense not to do it.
Right. Well, that's the case with doctors and R1s and one other group that's in there.
So, Greg, I want to get your question on this. Will the Biden administration change historic policy position and allow for adjustment filing upon approval of an I-140, regardless of priority?
Well, I wouldn't be surprised if they do that. But USCIS is definitely not going to do that unless the White House tells them to do that. That's the sense I'm getting from people that are advocating on this, is that USCIS has dug their heels on the position. But, Congress sent a letter, not Congress, but members of Congress sent a letter last week, a lot of allies of the president on the Hill, that will get attention because of who signed it. And there have been some good some good articles and some good legal analysis, including by our friend Cyrus,
Cyrus had a great article
who've explained, the legal theory and, the USCIS, they have their own internal legal reviews, but their bias is always biases to say no. Even if they are sympathetic, they're really afraid of change and they're really afraid of taking aggressive positions. And it seems like the White House usually has to push on an issue for the agency to make the change.
Well, I have a take on this from the USCIS. Another reason why they're hesitant on this. July 2007.
Oh yeah.
The 485 apocalypse. So immigration took in that within that 30-day period something like $500 million in some crazy amount of money. Right before their fee increase was going into effect, which is why I think Charlie is a hero.
That was that was in the days I had a very popular blog back then, and I was getting all kinds of interesting.
And so immigration took all this money in, and by the time they retrogressed immediately, and by the time many of these people were current, and there's still some that are still adjudicating, they had no money. I mean, that's the problem with immigration. They're not going to take in $1 billion and put it in a CD and then draw it down as they need. They're going to spend it. They're going to find some way to spend the money. And so I think their biggest concern, Greg, is they take all these cases and they have a physical way to do them. Yeah. They have no physical place to store them. They have no physical place nobody to adjudicate them. They have the money to pay the adjudicator. They don't have the capacity. And I think that's a key part of what they're probably pushing back on the White House on. But I would tell you, my position is they absolutely should do it. There's no legal justification.
My thinking on that is when there will be a connection between when e-filing becomes available in a certain category and their willingness to do that kind of thing.
Yeah.
On there, when we have e-filing available for adjustment applications, that will probably be when they say all of a sudden their legal position will evolve as soon as we get to that point. So it's sort of going along with what you're saying, which is probably the main reason they're opposing.
T. Lyons, thank you for the great comment. Good morning. 601, we talked about 601 earlier. Dulce. That's my puppy. If dismissed, will the out-of-order adjudication case be admissible? I don't understand that question. Will they be adjudicative? Can they adjudicate them? Yes. I mean, but I don't know what that question means. If they're certified, will they likely? Oh yeah, this case. If the judge certifies a class, settlement discussions will start immediately. Yeah. They don't want the judge ordering anything on this case. Tim, good to see you. Thanks. Great to help you on this. I hope your green card gets current soon, my friend. Is there anything else I should be doing? Help my case, overstaying my visa or a pandemic, have 601 pending. You know, just got to do it. Well, if you came on a visa, why do you need 601? You have to be out of the country, right? So, I get it. You say overstayed your visa, you left the country, and then you got stuck with the bar. The bar got tripped. That's too bad. That's bad lawyering, I think. How much longer do you guys think it take the final decision on 601? I think Aaron talked about. I don't know. I mean, hopefully it's a matter of a few months. I was hoping. I mean, our goal always is to do the whole thing within a year, so hopefully soon. Continuous bill EB5 attached. I don't know what that means. Ominous bill. I reached out to Center recently, and they have been helpful. Yeah. By the way, lots of people are asking for expedites on 601s, and they're denying most of them. They're denying almost all of them. In fact, Greg, the data scrape that you sent yesterday, you sent me the 601 data scrape of all the cases. And there every month has people that have been approved that must have been expedited, but they're 3 or 4 or 5. And they're being very difficult on expedited cases. Saint sent, yes, DV21 is still not decided. 11 months from the oral argument, which I think was September 8th last year, September 11th, something like that. My senator said it's not her area of influence. What? I don't even know what that means. Your senator refuses to help you because they like Trump? I don't understand. I don't get that. It doesn't matter whether they're pro-immigration. Their job is to represent you. Oh my gosh. You know what? There's sort of a different attitude a lot of times on constituent services, even for members of Congress that take anti-immigrant positions. I would not necessarily assume that your member of Congress is not going to be helpful because they're viewed because they're anti-immigration. Their constituent services are generally really good. They're there to help people. You're also trying to do it the legal way. Yeah. On there, and that's a way a lot of times members of Congress can kind of distinguish between their view. They don't. A lot of them don't want to say we don't like immigrants. They just want to say we don't like illegal immigration, and we want people to go the legal way. So that's how in their head they'll justify helping you. Yep. All right, Greg, it's been great to see you this week. We'll be live again next week. I'll be live tomorrow at noon. Do you have any lives this week, Greg? You can do anything else, or you're just too tired from the Ragnarok or whatever it is that you just did? No, I got a lot of catching up to do. Okay, it's not Thor Ragnarok. It's Greg Rye. Greg Rye. It's an acronym. It's a terrible acronym. It is. Terrible acronym. We'll see you guys next week. Bye-bye. Bye.